However, as a result of his career change and the birth and age of the minor child, he no longer has use for these guns to be in his home. And as you will hear from Mr. Hawkins himself, all of the firearms in which the petitioner will claim that he has are no longer in his possession, and that they are in fact secure in a protected place outside of his home and are at no risk to the party's minor son. He will not he is willing to offer the petitioner with the serial number for the firearm that he currently had in his possession, as well as the one that he turned over to his job after this action has been filed. Therefore, at the end of today's hearing, after you will hear the evidence how Mr. Hawkins is not a threat to Ms. Stewart's safety, how he has never harmed her, has never inflicted violence against her nor their child, we would respectfully request that this court deny this petition for a protective order and not grant the 12-month protective order, as this matter is not proper and should be properly conducted in Superior Court under contempt or modification action. We will prove that Mr. Hawkins has done nothing to put Ms. Stewart in imminent fear of her or the minor child's safety, and instead should go away with this matter so that the parties can proceed with their lives and continue to hopefully effectively co-parent in the future. We would request that this court deny the petitioner's request for any type of cost, any type of family violence treatment that would be imposed, and that we would also request that this court deny the petitioner's request that Mr. Hawkins' visitations with his minor child be restricted, be supervised, or any different than was agreed upon in the parties' final judgment and decree of divorce, as well as the joint consented parenting plan. And we would just emphasize that Mr. Hawkins by no means should have a protective order issued against him at the end of today's hearing. Thank you, Your Honor.
Thank you both. Before we actually begin, let me explain, as I had explained to both counsel, there are a number of issues perhaps that will arise today over which I will have zero jurisdiction and may be better served for both parties and the child in handling. There are going to be issues that y'all are both going to need to handle anyway in Superior Court on the divorce action. So our jurisdiction is fairly limited in what I can and cannot do. I have to be mindful of the order that does exist, but there will be issues that I can't necessarily modify here, but we'll address those as we come to them. So with that said, Ms. Shockley, you may go ahead and call your first witness.
I call Dr. Courtney Stewart. Should I swear?
I'll let you swear in.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Please unmute.
I do.
Okay.
Could you please state your name for the record?
Courtney Eileen Stewart.
And were you previously married to Mr. Harry Adam Hawkins?
Yes.
And do you have a child with Mr. Hawkins?
Yes.
What is your child's name?
Harrison Stewart Hawkins.
And how old is your child?
He'll be 17 months at the end of this month.
And what is the custodial arrangement which the two of you reached by settlement?
I have sole legal and physical custody.
And does Mr. Hawkins have visitation?
Yes.
What is that current schedule?
He currently has the first and the third weekends from Friday at 4 till Sunday at 6, and then the Thursday night preceding my weekends from Thursday at 4 p.m. to as late as 9 a.m. on Friday.
All right. Can you describe the frequency? Let's not talk about the content yet, but just the frequency of communication you received from Mr. Hawkins and the types of communication?
Yeah, so he typically through text messages, text dozens of times a day. Also call as well. I tend to block him when it's not his parenting time with Harrison to avoid these calls. But then he just calls my work number when he knows I'm at work to talk to me. And we'll call, back to back to back until I answer. And then if that doesn't work, then he'll send an Our Family Wizard message. So it's just pretty nonstop communication. I think the most times he's ever called me is 30 times in one day. That day, there were probably also at least 25 to 30 text messages.
Your Honor, as a technical matter, the exhibits that we forwarded to the court, how do you like to handle that? Do you like to do screen share or?
If you will let our staff know what exhibit you wish to present, they will pull it up and we can all see it from there.
Okay. All right. Let's go ahead and jump to the text messages. If we could please see exhibit L, petitioner's exhibit L. Ms. Stewart, can you identify this document for us?
But we haven't gotten it pulled up yet.
Oh, wait, yeah.
Right in front of her, I didn't know if you did.
That was not. Oh, I think you mean. I think you mean Exhibit M, the text messages.
Is it M or L?
M says text on the directory.
It is actually L, I believe. It's
L says email.
M.
oh. You could open. Let me see M. Maybe I missed.
Okay.
Yeah, it's M.
I apologize. Misnumbered my own exhibits. Okay. All right, Ms. Stewart, could you please identify this document for the court?
Yeah, this is a PDF of messages between Adam and myself from December through, I guess, beginning of February.
And obviously, we don't have time to go through every piece of this correspondence, but I would like to tender this as plaintiff's M and ask Ms. Stewart some questions about it if there's no objection.
Any objection, Ms. Robinson?
No objection, Your Honor.
All right, may proceed. It's admitted without objection.
All right. Let's start with if you look at the bottom of the first page, where it says the first payment is due 1/1. Can you tell me a little? Can you give me the context of that statement? That's coming from you, correct?
Yeah, the blue is from me. This is part of our settlement agreement. I have to pay out of $220,000. And so the first installment was $200,000, and it was due on January 1st, 2023.
And so you were responding to his.
Sorry, did y'all hear that? Her first payment to him is $220,000. Listen on.
Statements prior to that, which basically in which he demands that you start making the payments now, correct? Tells you to take out a loan.
Yeah, he wanted the entire amount, the $220,000 he wanted it all at once, and he didn't want to work with me until he got his money. And this is from the beginning of December. I think the case had the divorce had been finalized for maybe like 5 days at this point.
And so the payment was not due at that time.
No.
All right, can we turn to the second page, and if you could just read the court, that page in the text message. I guess I don't know exactly what we would call it, the log.
From what part of it? From where I talked to him, or?
Just from the start of you've only paid for problems, just
Oh, yeah. So he texts, you've only paid for problems. What a waste of money. Please get Harrison. This is stupid. Thanks. I don't want to talk anymore. Do you enjoy this? Because I'm fucking over it. And I just picked him up.
Excuse me here, Ms. Shockley. As I said a few moments ago, I have no interest and no jurisdiction over whether or not these payments. I'm here about one issue and one issue only. So
Correct.
if you have something in this very lengthy exhibit that is an example of alleged violence or threats of violence or that sort of thing, please proceed to that.
I'm sorry, I was just
Y'all can fight all day in the divorce action as far as contempt.
right, and I apologize, Your Honor, that was not the point. I was just trying to give some context, and the payment is not at issue. I think you'll see that the next sort of statements start to get into the threatening.
Then please, well, you said approximately an hour and a half, and so we need
Yeah,
to get
okay.
moving.
All right, okay. So, Ms. Stewart, could you continue to read from that page, please?
Yeah, it's all right. I just picked him up, and then you said this is only going to get worse. You have no idea how bad this is. Your medical is canceled, asshole. All right, okay, thank you. I'll get coverage first ASAP. You sure fucking will. You should have gotten this when you canceled my car insurance since you want to play that way. I'll never forget any of this. You're only making things more difficult for yourself.
All right, can you flip to the next page? Do you see where you asked for, let's see. So do you see the statement, I told you you're only going to make it more difficult on yourself?
Yes.
When you see statements such as that over and over again, and they're throughout this document, how do you interpret those statements?
I interpreted that Adam is threatening me that if I do not do things his way and the way he wants to do them, then there's going to be consequences and repercussions for me. You know, this is why we're divorced, so I don't have to do what he wants me to do. I can have my own thoughts and opinions and do my own things.
And for example, in his next statement, it's all fun and games with your stupid baby boys till you realize the game is over. What does that imply to you?
I mean, it means that he has something planned and there's some sort of retaliation coming. If he doesn't get what he wants.
Okay, hold on, please. All right, Ms. Robinson, your objection?
Speculation as to the meaning of Mr. Hawkins behind the statement. Ms. Stewart is not in the mind of Mr. Hawkins, cannot testify as to the motive or reasoning behind these statements, only to what they say themselves.
All right, Ms. Shockley.
She can testify as to how she interprets them.
I'm going to give a little bit of leeway here.
All right, and so
When there are alternatives to, as far as recourse for either party to file new actions in court, you have the burden of proof that acts of violence or threats of violence have been made. If a line can be interpreted multiple ways, it may not help your case. You may want to spend more time on those that can actually help your case than going through all of this line by line.
thank you, Your Honor. Okay. With that in mind, let's take some testimony, and we'll potentially come back to Exhibit M.
All right, thank you.
Absolutely. All right. So, Ms. Hawkins, can you give us some background as to why you ultimately did decide to file for a TPO. Can you give us the back pattern leading up to you filing?
Yes, the divorce was a contentious and hellacious 11 months. And I truly thought that when we reached mediation, when we went to mediation, we reached a divorce settlement and the divorce was finalized, that the behavior would improve and things would settle down. And now we had a plan and everyone knew what we were supposed to do and things would not be an issue anymore. However, instead of that happening, Adam became more and more upset about the agreement and his visitation and his time, um, claiming that his counsel was ineffective and that he was coerced into this settlement, and that, this wasn't fair and that I was going to pay for things. And so he would, show up at my front door unannounced, demanding time with the baby. He would threaten me. We would do nightly FaceTime calls so he could see our son, even though he doesn't talk back yet. And during those phone calls, he would use that time to interact with our son as much as you can on FaceTime, but then also, tell me I was going to regret this, I was going to pay for this, things were, things weren't going to be my way anymore. And then it got to the point where the beginning of January, we were on a call, we did a FaceTime call, and then during that call, he made threats to me about harming me. And, he said, if you don't allow me more time with my son, I will kill you. And, I believe him. I believe he's capable of doing those things. And then I guess it was like a week or 2 weeks later, there was a terrible weather day and daycare closed early, and I was able to get our son from daycare. It was before Adam's time started at 4 p.m. Adam was enraged that I had gotten our son from the daycare instead of him, demanded I bring the child back to daycare, which was closed, demanded I wake the baby up from his nap so Adam could start his time with him. And he was making threats to me. If I did not comply, there would be consequences and things would happen to me. As I know, Adam always has a gun on him. I very much thought that he could shoot me, he could hurt me, he could threaten me, and so I complied with him. And his behavior then continued. A couple days later, when I guess it was the next week, when he had his Thursday overnight, and he was supposed to bring Harrison back so I could take him to the doctor's appointment, and he chose not to, and he was, on the phone was very, when I did reach him, he was very threatening, and then he discontinued answering and stopped communicating, and, I just realized that, he...
About where your son was at that time?
Yeah, I did not know where my son was. I called the police, and they said it was a civil matter, and they couldn't make him bring my son back. And I didn't know where he was going to be. All I knew was he, had lied about where they were. And, and he just told me, if you don't let me do this, then, you're going to regret it. You're going to pay for this. It's always, I'm going to pay for this. And he has, I just was done. It's been a long time of dealing with these threats and these actions, and I thought it was going to get better, and it just hasn't. And so that's when, I decided that I needed to take some actions to make sure that he realized that he couldn't continue to act this way, that there would be consequences, and that I, needed to feel like I could be safe in my own home or just anywhere.
So in discussing being safe in your own home, did Mr. Hawkins ever damage any property in the house when he lived with you?
Yes, he kicked a hole.
Excuse me 1 second. Ms. Shockley, let me also add one thing. I'm not going to consider anything that is not referenced in the petition. Is this in the petition or not? If something has happened since the filing of a petition, yes, I will consider that evidence. But I'm not going to go back. We're not going to dredge up things that are not in the petition. The respondent is not on notice, has no due process, uh, giving him the advantage of what he's being alleged to have done.
I understand, Your
So
Honor.
we need to restrict it. If you need to go back and look at your petition, that is all I can hear.
All right,
If
thank
you
you.
need to amend your petition, then we'd have to continue the case, but it's too late now.
I understand, Your Honor. That was pre-divorce, so I understand. Miss Stewart, oh,
I'm confused, Your Honor, because the evidence portion said any past acts of violence or damage or proof of violence should be submitted as evidence. It didn't say that on the initial ex parte petition.
If it was not referenced in the petition is served upon the respondent, telling the respondent what the allegations are, the specific allegations.
I'm looking, hang on, Your Honor. I believe,
No, Your Honor, no.
I did not mention it because I thought it was only dealing with the exact threat at the time and that I'd be able to show his history of stalking and violence when we got to court.
There, sometimes people will respond with the actual accusations that something happened 6 months ago or whatever. You know, we can't go beyond the petition.
okay, we understand, Your Honor, thank you. So, in talking about, Mr.
And you can shake your head all you want, but I'm bound to hear only the evidence as to what has been alleged.
Could you describe, Mr. Hawkins' behavior, in the hospital the day that you all did ultimately arrive? Where give us the background again. He did not show up for the appointed time. And how did he behave when he ultimately did show up with the child?
Just really feel like I'm being discounted right now. So this is really hard. You know, yeah, after I called the police and they contacted him and they said they couldn't make him do anything, bring him back, and he showed up an hour and a half later at the second medical appointment, and I had asked that he not be allowed to attend the appointment given our interactions, and I wanted security to make him leave, and he, played the victim and said, she's doing this. She gave me permission to be here, even though that's not the case. I hadn't rescinded it after his threatening behavior the day before. And, and he told me, you're going to pay for this. Like when I got the baby back and walked away, and, he said, you're going to regret this. You're going to pay for this. This isn't the end of this.
And can you tell the court a little bit about some of Mr. Hawkins' behavior at the daycare center that has caused you concern?
Yes, when we were operating under the temporary agreement, he was not allowed to pick the child up for daycare. So I would pick him up from daycare and then we would meet him later. He went to the daycare and demanded, to see like sign in logs, sign out logs, demanded all this information that he is not entitled to. And I got there and he was screaming at me to fuck off in front of a bunch of infants and toddlers. And, telling me again, you don't control this, you'll pay for these behaviors. I'm his dad. It was, I had to have a conversation with daycare afterwards to make sure we weren't kicked out of the daycare from his behavior. And they said, they would ban him from the property if he behaved like that again.
Can you describe an interaction that you had at the bank when you all were there? You can give the court the background of why you were there and then his behavior and what occurred.
Yeah, we went to the bank he refused to give me the information to make the wire transfer for the settlement money so I could be in compliance with the order.
Okay, Ms. Robinson,
I would object to relevance at this time. These particular circumstances, as well as the previous circumstances elicited from Ms. Stewart, were not issued nor alleged in the complaint, and they have no bearing on today's hearing in regards to the family violence matter that this court is here to hear. And since pursuant to your previous statements, since this was not properly advised in the complaint, that we would just request that this testimony be stricken from the record.
Ms. Shockley, your response.
I believe it goes to a pattern of behavior. I believe that it falls under stalking, harassing behavior that is alleged. It's not every incident wasn't written out. No, but she has alleged the harassment. She has alleged the abuse, and these are examples of those things. And he is aware of his behavior, and I think he is on notice of the fact that these would be issues that would be brought before the court in a TPO hearing.
Perhaps if that is your aim in terms of eliciting this testimony, that there needs to be some clarification as to when these incidents occurred.
Certainly, Your Honor.
It could have been 6 months before I realized it was divorce related, and I don't want to get into the merits of who did what in terms of compliance with the divorce itself.
Correct, and that's
I
not.
understand if it's the spark that caused the fire, then I want to hear more about the fire than the spark, if you will.
Certainly, Your Honor, and this was post-divorce
Okay.
in recent times.
Okay.
So in the back.
I'll overrule the objection at this point,
Okay, so.
but I am instructing Ms. Shockley to get to the heart of the matter as far as how it ties into the actual allegations from the petition.
Certainly. So you were in a public place in a bank, is that correct, Ms. Stewart?
Yes, on December 31st, 2022.
And why were you there? Meeting him?
Because he refused to provide me the information so I could do the wire transfer of the $200,000. And so therefore he demanded we meet at the bank.
Rather,
to-
you wanted to see you in person.
Yes.
Okay. And can you tell me how he behaved in the bank?
Yeah, he was in my face. He grabbed papers out of my hand and ripped them up. He was very much aggressive posture and threatening, to the point where the bank asked if we needed to call security or they needed to call the police.
And how did that scene end?
He stormed out. And then after some period of time, I don't recall the exact amount of time, he calmed down and he said he wanted his money. So he and I wanted to be in compliance with the settlement agreement. So I agreed to go back to the bank and meet him again to make sure I could get him paid.
Thank you. Does Mr. Hawkins own personal firearms in addition to those that he has issued through his employment?
Yes.
Do you have any idea how many firearms he owns?
At least 24 by the last count I had when they were in the house.
Okay.
And some are assault rifles, actually multiple are assault rifles.
And after he was served with the TPO, as we sit here today, it is our understanding that he has not complied with the ex parte TPO and submitted those or relinquished those firearms to law enforcement, correct?
Not that I'm aware of.
And does that cause you concern?
Yes, because he can be at my house in 3 minutes.
And do you have concern that he generally just simply doesn't obey rules?
Yes. He didn't follow the court's temporary order from February of 2022. He didn't follow the divorce agreement from November 22, and he hasn't followed the TPO. and he's had zero consequences to not following any of these orders.
Let me ask you, they mentioned, or Ms. Robinson mentioned in opening that you were, quote, in contact with him after filing the TPO. Can you explain that to the court, please?
So I filed the DPO on January 16th. I had the hearing on January 19th. So in between that time, I continued to communicate with him because it wasn't granted. And then I was informed that I had to continue to, the visitation and everything else had to stay in place until he was formally served, which didn't happen until the 26th. So I had to just continue to act like I hadn't filed this, so that until I had legal right to act any other way.
And so once it was served upon him, did you communicate with him after that?
The day it was served, I was asked by your paralegal to find out his office numbers in case we needed those as well. So I did once I knew he was not at his office because it was after 5 o'clock. So I knew he was there. So I did call the office numbers from old emails to verify if that was his actual office number because I honestly wasn't sure.
But that was the only, what could have appeared to be attempt to communicate that you made post him being served with the TPO.
I did take screenshots of the calls from after he was served the TPO, and doing that, I did press the button to call him and immediately canceled it. So it was a less than a 1 second thing. There was no communication. It was just trying to take images of his calls after the TPO.
And he did, to your point, in fact, try to call you numerous times after being served with the TPO, correct?
Yes, and FaceTime and sent our family wizard messages.
Did he also text?
Sorry about that, y'all. I was watching this in double speed until I caught up. So now I have to fix the speed so they don't sound ill. My kitchen is clean. Okay.
You.
Yes.
And when you did not respond, what was his excuse for ignoring the TPO?
I believe it's in the text messages.
I'm trying to get through this with as quickly as possible with testimony and exhibits.
Okay. So February 2nd, he texted, I requested to see H on FaceTime. It's been 11 days and there's not a valid TPO. And that was, several days after a week after he had been served.
Thank you. Can you explain to the court how his behavior is impacting you on a daily basis, and how it just in all areas of your life, how his behavior impacts you?
Yeah, once he left the house last March, I felt a little better, but then he would show up at the house whenever he wanted to, demanding to be, let in under the guise of seeing our son. The internet issue that has caused me, he's known about my communications with my attorneys. He's known about things that otherwise he wouldn't know about unless he was cyber stalking me. So that's led me to now only send emails through a VPN. I disconnected my doorbell because I don't want to know if he's at my front door. I keep the blinds of the house closed. If I have people over, I make sure they park in the garage so he doesn't know people are at the house. I'm afraid to take our son to the grocery store and run into Adam because we literally live 1.2 miles apart. And I just don't want there to be a public scene. And so I don't go to the grocery store. I've just had to change my life and how I live so that I don't interact with Adam, don't possibly do things that would cause him getting angry and upset and making a public scene, and causing us to lose our pediatrician or lose our daycare, or I've had people who don't want to help me with our son because they don't want to interact with Adam. They're scared of him. And so it's been very isolating.
And are you scared of him?
Yes. I asked him to go to counseling a long time ago, and he's refused, and he's continued to get worse. And I never would have thought we would be here.
I also wanted to address something that was raised in an opening, and that was that he has alleged that you have been violent to him. Now, obviously, that is not in any petition or whatnot, so it probably doesn't need to be addressed. But, Your Honor, is that something that you would like to hear about?
Well, I would suspect it's going to come up on cross-examination since it was in respondent's counsel's opening statement. But if you wish to address it, that door has been opened.
I think so. Okay, so could you please tell exactly what occurred, what we are assuming he's alleging occurred, since she did raise that in the opening, that there was an incident where the police were called on you for alleged domestic violence. Can you tell us about that situation?
Yeah, that was last February, February 2022, when we had our temporary court hearing, and he and his family were instructed to only use the basement apartment in the house and enter through the exterior door, to no longer access the garage. And he, as his nature, decided that that order didn't apply to him and he could continue to be in any part of the house he wanted to be, including the garage. And his family his sister felt the same way. So we got into an issue where I was trying to keep him out of the house and he was trying to come in. My mother was on the side where I was, his sister was on the side he was. Anyways, it resulted in him claiming that I had scratched him, which I did not do, and I allege his sister did. And then they called Brookhaven police, and Adam became irate when the officer refused to have me arrested. He demanded a sergeant come. The sergeant came and said, "We don't believe that this is, that you did this," but he is irate and he is demanding that you be taken to jail. He said, "We're not going to do that." And so then they ordered, and then Adam ended up being upstairs alone in the house with my mother, and he threw a chair at her, and the police ran upstairs, ordered him to leave the house for the night. However, he returned an hour later. And the police at that time recommended that I might want to file for a TPO, but I didn't want to pursue it at that time.
Thank you for that explanation. All right, and you heard in the opening that he's willing to do certain things, such as give you an inventory of his weapons and things like that. Were those not already requirements under the divorce decree?
Yes, that was a requirement in the divorce decree that he's failed to meet.
And he's also failed to put the put the guns in a safe. He never retrieved the gun safe from your house.
Correct. He never had it moved to the apartment.
We have no proof that he doesn't have the guns at his house other than his word. Is that correct?
That's correct. He alleged that he moved them to his parents' house, but then the next week he told me he hadn't seen his parents in months. So I feel like he was just lying about where the guns are.
And when you all were together, did he always secure the guns or not?
No. There was always an unsecured gun. He always had at least one gun on him, and then he always kept an unsecured gun in the couch in the basement.
Is that a location where a toddler could access that gun?
Yeah, it has a little compartment that flips open, and it's in one of the exhibit pictures, but it's easily accessible. Harrison loves a hidden compartment.
Again, trying to stick with just testimony so we don't have to go through.
Well, you can go through, I'm not telling you how to try the case if
I know,
there
I do want us to get through this today, and I believe we've.
we're gonna get through it today. I can assure you.
Okay.
It may be, I may have to postpone if we get this other case in here, which is due at 1 o'clock. I may postpone you until afterwards, but we're gonna get through it today, however long it takes.
Okay, all right, wonderful.
But I would appreciate efficiency though.
I understand. Okay, if you could return to, I just want to do a couple of examples here. If you could return to Exhibit M, Ms. Stewart.
Okay.
Okay, let's wait and let staff pull it up, please. And if you can identify what page we need to go to, that would be appreciated.
Yes, page 15. Okay, could you start with?
Are we on page 15?
I'm not sure, Your Honor. That appears to be it. Yes.
Okay.
Yes, Judge, page 15.
Okay, thank you.
Could you start at the very bottom where it says "I dare you to try anything," and could you read for the court the next several pages or the next page?
Yeah, so he writes, "I dare you to try anything. You have no idea what I can do." On the next page, he says, "Bring it on, asshole. It's on now. F off." You want me to keep reading? Oh, okay. So it says, and I say, "Adam, it's written in the agreement. If you cancel your time less than 48 hours notice, you're responsible for any child care costs I incur." He wrote, don't care. You did this. You deal with every problem. There are going to be tons. What you've done is horrible, and I don't care. If it's going to suck for me, it's going to suck for you too. And I said, "You're choosing not to spend time with Harrison. That is on you." He said, "So what? What about what you've done? That's on you."
All right. You can stop there.
Okay.
All right. Let's jump. And again, how do those comments make you feel?
Yeah, and I mean, this is again just when things aren't going the way he wants them to, then he gets angry and it's just threatening and bring it on. And this is not over. This is not a game. It's just, to me, how I interpret that is that he's planning something. If I don't do things how he wants to do them, there's going to be retaliation.
Thank you. Okay. All right. If you could turn to page 30.
Okay.
Ms. Shockley, if you will direct her attention to something specific so we can move on.
Yes, certainly. Okay, so I'm sorry, if she could turn to page 30.
Yeah, she did.
Oh, okay, sorry.
Thankfully, and I've just now figured it out that it's got the page that she can access by skipping all the other pages. So we're there.
Perfect.
Okay, great.
That was faster than I thought too. Okay. All right. So, if you could start with, let's see, actually just at the top, and where it says, then just tell me when I can get the safe.
He said, just tell me when I can get the safe. I thought you would have learned games are over. Some people just never learn. And so I wrote back, the safe is legally mine because you failed to get it. You can buy it for me. Bad move. He writes, bye. You have failed at every attempt. I don't want that safe. It would have been 400. Just move it. I'll just get a better one for my home.
Excuse me for interrupting. So the safe is actually your property?
No, he was supposed to obtain it when he moved out and he never did. And he had a deadline to get it by and he didn't get it by that deadline.
Okay.
And so then just, I would like to note, as you flip through the next several pages, who is corresponding and who is not responding.
Or you just want to scroll through the next 3 or 4 pages or what?
Yes, if you just if this is the type.
Are there any specific text that you want me to see?
I'm really just looking more at the volume.
Okay.
X. Similarly, if you will scroll to page 43, and once again,
All right, we're there.
once again, if you could just continue to scroll down to show the excessive amounts of text messages.
What are the dates of these? They're scrolling pretty fast here.
These are this January.
Okay.
All of these text messages were post-divorce.
Okay.
This is all one day, these couple pages.
Well, I'm looking at it in terms of the time frame relative to the filing of the petition.
Correct, and it was right before she filed.
Okay.
Okay, I think we're getting now towards the end there. Thank you very much. Okay. All right, I think that's all I have right now, Your Honor. I'll reserve redirect.
Okay, do you have any other exhibits that you wish for us to see?
Yes.
I think that there's been, all right, actually, yes. If we could turn to Exhibit E. I know, I'm sorry, I'm trying to.
And I appreciate you trying to make it efficient, but I just wanted to ask the question in case there was anything else in your presentation with this witness.
Certainly, I understand, Your Honor. Exhibit E, HAH firearms.
Okay, are you going to ask any questions relative to this?
Sorry, I'm so sorry. I've lost my Zoom screen.
We can see you.
I know. Probably can, and I can't see you. Where are you? Now we're back. Okay. All right. Okay. Ms. Stewart, could you please identify Exhibit E for us? And you can, if the court reporter could scroll down so that we can see both pages, please.
Yeah. So the first.
Yeah, let her do it one at a time, please.
Okay.
Can you identify this picture, Ms.
Yes.
Stewart?
Yes.
Okay. And
yeah, this is a picture of Adam's handgun.
okay, and does he still own that sofa, to your knowledge?
Yeah, that sofa's in his apartment.
Your Honor, my lawyer, it dropped offline just to
Oh,
let you know.
I'm sorry, I didn't see it because everything was over to the right.
Yeah,
Let's hold on, let her rejoin. Thank you for calling that to our attention.
Well, we're just waiting for her to sign back on. Interesting case so far, don't you think? I think that the judge is done with the Zoom. He's so finished with the Zoom completely. Anyways, it gets really good here because um the husband actually testifies and oh, here we go again.
Oh gosh, and she was texting me and I didn't see it. She was saying, I haven't heard anything.
Welcome back.
I'm sorry. Can everyone hear me?
Yeah, we're gonna go back to where we were in case you
I'm
missed.
literally on the hotspot, so I think it must be the weather because the hotspot is. I'm so sorry about this inconvenience. It's just not working for me
Okay.
at all today.
Did you leave us during this exhibit?
And you probably can't hear me, but I can't hear you that well either.
We can actually hear you, Janae.
Does it work better if I turn my camera off?
We hear you fine, but
Oh, well, great, because I can't hear anything. But that's fine.
okay, can you hear us now?
I heard you make that comment, but that was the only one.
Okay. Are you hearing us now? Okay. All right, let's start over with this exhibit, please.
I'm sorry.
As far as the identification of the exhibit.
Okay,
Ma'am, if you would go ahead and state your answer as to what this picture shows.
Yes, the picture on the first page is a picture of a gun in the couch.
And what is on the second page? Scroll down. If you can identify that.
The picture of some of Adam's guns, but this is how he was transporting them to the apartment when he moved out.
I'd like to tender petitioners E. There's no objection.
All right, any objection, Ms. Robinson? Ms. Robinson?
I'm sorry. It's really delayed. I do apologize. In regards to this, if you can hear me.
Yes, we can hear you now. You froze up for a minute. All right,
As did y'all for me as well. So
okay. She just tendered this exhibit. Do you have any objections?
okay. Not at this time. No objections, Your Honor.
Okay, admitted without objection. Anything else, Ms. Shockley?
One more thing, Your Honor. I'd like to see Exhibit B, please. Petitioner's Exhibit B. Dog is going crazy in the background. This has just really been an entertaining event. And could you identify this
I'm trying to block out their email addresses.
For the record, Ms. Stewart.
Yeah, this is a copy of our family, some of our family wizard messages.
Okay. And can you explain to the court very quickly why we chose to select this this particular outtake, shall I say, of the our family wizard communications?
Yeah, the full communications are probably around 100 pages. So the first page of this is just all our family wizard messages from after Adam had been officially served with the TPO. Actually, the first 2 pages
So
are
those,
that.
okay, and so you were not responding because he had been served with the TPO, correct?
Correct.
And then could you flip to, I think it is the third page. The date is 1/13/2023. So this was prior to him having been served. Can you read that?
Yeah, this is prior to me filing for the TPO.
This was right before you filed, correct?
Yeah, this was the morning of that. Where, yeah, I had, I essentially in my communication, I told him that, essentially I said I cowered to his threats yesterday and I handed Harrison over at 2 p.m. That will not happen again. I was telling him, if he causes Harrison to miss the appointment, I would call the police and I would bill him for the appointment. And that's when he responds that a false report is a serious crime.
All right, and that was the incident that you were discussing earlier about him threatening you and saying that he wanted the child right away, etc. Correct?
Yes. Mm-hmm.
And then could you flip to it's the date is 1/12/23.
What's the page number? I'm sorry.
Sorry, it says 1 of 2 at the bottom. I wish these were
2, 3.
Hold,
It should be
hold on,
page 5.
hold on. I think we've lost Miss Robinson again.
Your Honor, just an update. She's attempting to connect right now.
Text from her. She says trying to log on again and have tried multiple times, but it's not connecting.
I may have spoken too soon about resolving it all today. I may have jinxed myself.
All right, she's gonna try her phone now.
Okay.
That's her heart. So frustrating.
Welcome back. Can you hear us? Okay.
Yeah.
All right, Ms. Robinson, I'm not sure what the issues are, the technical issues, because I'm not very tech savvy myself.
Neither. I went to law school for a reason.
Well, that's why I avoided math classes too. So, if this continues, I may have no alternative but to, on the court's own motion, because we've started this hearing in a timely fashion as required by law. I can continue this hearing until a later date, and the ex parte order will remain in effect until that time. I can't keep having the dropped calls here, or dropped videos or whatever, but the dropped connections, because I got 2 other cases that are coming in this afternoon. They may already be here for all I know. And this was originally going to take about an hour and a half, and we're at that point now. And I realize you haven't even had an opportunity to get to your side of the case, so it's I'm not holding that against you, anything like that, or against the petitioner, because we've had a lot of delays. Let's see how we go, and if it continues, then I may have no alternative but to move this to March the 1st to finish it.
Okay, Your Honor, I will say that in the event, as you had stated previously, if we needed to report back at a later time, I can go home where I know I have a very stable internet connection as opposed to here, so that we could proceed today if that would be something you'd be open to. I only live 20 minutes away, so it wouldn't be extended delay if you were to hear another case in that interim, but I definitely understand and
Well,
apologize for the inconvenience that
it's certainly my goal to finish it today. If we can figure out a way to do that that'll actually work, and we may try that as an alternative. But let's see how far we go now.
Okay, yes, sir.
Maybe you need to upgrade your Wi-Fi.
I will tell my boss that. I definitely will.
Somebody needs to.
Yes, because the whole office is down, so I do apologize.
Okay, so
Who's your carrier?
I think it's Xfinity.
Okay, that explains it.
Yes.
All right. All right, Ms. Shockley, you're back on.
Yes, picking back up with Exhibit B, could you please, Ms. Stewart, walk us through, and this is, so that the court understands, this goes in backwards in chronology, correct? So the exchange that starts, at the bottom, or actually on the next page, I'm sorry, guys, that these aren't numbered, it would be page 2 of 2 for the court reporter's purpose, but it's just simply the next page. Thank you so much. Could you tell us a little bit about the what you were discussing here and how this ultimately ended? You know, just give us the background of what was going on, and then if you could read your last text message, which was actually the first text message at the top of the last page, to explain the issue right the day before you filed the TPO.
So this is the day there was inclement weather, daycare closed early. I picked up Harrison from daycare, as Adam's time does not start until 4 p.m. per our agreement. He was upset about this, and then that's what led to our exchange in my driveway, where he was threatening me, demanding to see the child. I felt like he was threatening to harm me if I did not comply. So I did comply. And then on the other page, the page we were just on, yeah.
Excuse me, if I may, has this piece of evidence, has this exhibit been entered into evidence? I'm sorry for my connectivity.
You have not tendered this page, have you? Exhibit B.
You know what? I think with all of the confusion, I think I've in my head forgotten to tender it.
Okay.
It was
All right. Would you like to tender it at this time?
Yes, I would like to tender it at this time.
All right. Any objection, Ms. Robinson?
Yes, we would just object to relevance. This has no bearing on the family violence issue
I just
of this nature, in which we're supposed to be here to handle.
All right, Ms. Shockley, your response.
This is a contemporaneous statement of right before she filed for her the actual entry that I'm about to have her read, and there's another entry that is very, very relevant and indeed goes to the threat on her life.
Well, you've stated what the threat was. I've not heard any evidence of that. I will overrule the objection to the extent that it relates to a conversation in the driveway. Now I want to hear what the conversation was. So I'm going to overrule the objection to the document as it leads to something that may be relevant. We'll see.
Okay, yes, Your Honor.
Okay, thank you. All right, if you wish to continue with your examination regarding the incident in the driveway.
Yes, so you can continue your explanation, Ms. Stewart.
Yeah, if you scroll up to the top of this page. And this was, so the message I sent at 2:39 p.m. was after Adam had left with Harrison after the incident in the driveway where he was threatening me. And I'm sorry I don't have a recording of that. I don't tend to go around recording my conversations with people. But I did put in here, you know, I woke up a sleeping child because you demanded it. I hope you're happy. Per the parenting plan agreement, your time starts at 4 p.m. on Thursdays, not release to daycare. Do not ever threaten me again, or I will call the police about your erratic and dangerous behavior.
Ma'am, what are you alleging the threat actually was? You've used the word threat twice in describing the incident, but I have no idea what the threat was. Was it a threat for legal action? Was it a threat of bodily harm? You have to be specific, please.
Okay. It's a threat that things will happen to me if I do not follow his commands and comply with him.
It's the continual use throughout these correspondence that you see of, you have no idea what I'm capable of, what I will do. There's never a direct threat, which goes, frankly, Your Honor, or there are direct threats, but in my mind, that's how I read them. But I think it also goes to the fact that he knows how to walk that fine line of, of saying you have no idea what I'm going to do instead of putting in writing.
Ma'am, Ms. Shockley, you're testifying now.
I apologize, Your Honor.
Yeah, I mean,
Y'all save
so-
all of this. Save all of this for argument.
So
Okay.
when he says things to me like, "You better do what I ask you to. Don't test me. Don't push me, Courtney. Don't test me." As as somebody who has lived with him and knows that he has a temper and has acted out before, and as somebody who knows that he is a police officer and carries a gun on him at all times, when he threatens me verbally, I take it as him threatening me physically because he carries a gun on him and he could choose to pull that gun out at any time. Because he does have a police background, he is very careful in how he words his threats and how he behaves when he does think he's being recorded or he does think things are being monitored. So my only defense to that is to put it in writing when something has happened to inform him, like, this is my documentation that you threatened me.
All right. Anything else, Ms. Shockley?
Just one final thing to that point. Let's see if you could just scroll down, Madam Court Reporter, and I will tell you where to stop. That might be the easiest thing to do. Right here, just right there. That's perfect. Okay. All right. So could you please remind the court of the context as to when this threat was made and then the reason why you put it in your correspondence in Our Family Wizard.
Right. So this is January 2nd. This is the day after Adam returned Harrison from his holiday time with him. We had just had a FaceTime with him. He wanted more time with him. I hung up on him because he had verbally threatened to kill me. And so I put that in writing saying, "Please, I do not want to talk to you on the phone. Earlier today, you threatened to kill me. I thought yesterday we had made progress towards a better place. And then today the emotional volatility kicked in."
Thank you. Okay, I believe we're done with that exhibit. All right, Your Honor, I believe I will conclude my direct with.
Okay. All right, Ms. Robinson, before we start cross, let me ask my staff, have we heard anything about position one?
Yes, Your Honor, no problem.
Yes, all the parties are here.
Parties and counsel?
Yes.
Okay. All right, well, I hate to lose the good connection we have right now.
It's okay. I can promise you, when I run home, the connection will be much better. I'm an AT&T person myself, so hopefully that'll kind of get rid of those issues.
Well, let's go ahead and begin cross-examination. Well, hold on 1 second. I got a message here. Yeah, let me ask. I'm gonna take 2 or 3 minutes and speak with both counsel and parties in that case. Let them know that where we are in this, and I may give them some alternatives as well. Okay, so we're gonna ask. I'm gonna just place you in the waiting room, or the staff will. I won't. If I tried, there's no telling where you'd end up.
Understood. Thank you, Your Honor.
All right.
Well, that's the end of part 1. And I will get part 2 going right away. Thanks, guys.